Good afternoon, everybody, and thank you for coming. It was a bolt from the blue, believe me, and how brutal and vicious it was. I remember Anna Christina was with me. We had just returned from an official visit to Berlin when it hit, and we knew immediately we had a problem. At the time, it was only an epidemic, but within days, it became a pandemic. And then we had to act. We had to act because we knew, every single one of us, that we could not afford to suspend our work. I remember at the time reading a statement by a government of a country not very far from here, which announced that access to the court is restricted. Courts will only hear urgent matters, matters which are currently enrolled for hearing in the normal course during the nationwide lockdown period will generally be postponed until after the lockdown period has concluded. And then in certain instances, subsequent legal processes may be attended to by way of electronic means. Social distancing guidelines will be enforced, and stringent health and safety measures will be implemented at courts. I've just said there was no way we could only hear urgent cases. All our cases had to be heard, and the Security Council made it clear even at the time that they were expecting us not to delay the proceedings because of COVID. As I said, we had very important cases ongoing, which had to continue. The problem was how. You will hear about how we dealt with this problem. And can I say that although it was a struggle on the way, we succeeded considerably well, especially since, fortunately, we were well prepared. In fact, we never had any significant delay in our work. Jesse will be dealing with this. Way back in 2001, when I first arrived at the ICTY, we already had the Sewage case, where the accused was confined to his cell in the Scheveningen prison because of his health situation. And we had all the technical and electronic means in place already to conduct the trial by video link to him. But managing a court during a pandemic is reaching a completely different level, which presents much more problems. Not only as to how to proceed with cases, but also how to deal with the staff, organizing them to work remotely from home, how to secure the premises, because some staff, and quite a considerable number, had to be present. Also how to organize travel for judges, defense counsel, and witnesses who are still needed to be present either in The Hague or here in Arusha. And it was no easy task, believe me. Right at the core of the matter is, of course, the question as to whether resorting to these measures could have, or indeed had, any impact on the procedural and due process rights of the accused in particular, but also of the prosecution. This, of course, can be dealt with here too during this panel, and I suggest that we deal with it at the second stage. Last but not least, we had at the time more than 50 convicted persons serving their sentences in a number of states, both here in Africa as well as in Europe. I think 3 states here in Africa and some 11 states or 9 states in Europe at the time. As you can imagine, there was a COVID problem everywhere. although they were under the care of the individual countries and prison institutions, we ultimately had a responsibility towards them, and I hope that we will hear something about how we dealt with the situation. If that is not the case, I can give all the details. So this afternoon we will be discussing this and also what happened in other institutions and national courts in different countries. The panelists this afternoon, I start with the Honorable Justice Francois Regis Rukunda Kuvuga. Since May 2021, he is he's president of the Court of Appeal of Rwanda. Additionally, he holds the role of vice president of the High Council of the Judiciary and serves as a commissioner in the Rwanda Law Reform Commission. Honorable Judge Justice Lady Nita Mujeni, who I know from before, she was appointed as judge of the East Africa Court of Justice Appellate Division in February 2021, and in June 2023 she was designated as vice president of that court. Next is the Honorable Justice Sir Dennis Dominic Ajay. Is a justice of the African Court of Human and People's Rights and of the Court of Appeal in Ghana. He is a member advisory of the Committee on the Nomination of Judges of the ICC, and he also served as the director for the Judicial Training Institute of Ghana. He is the chairperson for the African Judicial Education Network for Environmental Law and president of the Association of Magistrates and Judges in Ghana. Last but certainly not least, my friend Jesse Leff. I've known him for at least 15 years that he has worked as a legal officer, the ICTR and the mechanism. He has been a legal officer in 14 international criminal trials or appeals involving 30 defendants, and notable cases include the Bagozora at trial, the Karadzic, Mladic, and Stanisic and Samatovic appeals. So let's begin. I understand Judge Rukunda Kuvuga has a PowerPoint presentation as well. So you have 10 minutes, and then if you require more time, we will adjust accordingly later as we go along. Thank you.
Thank you, moderator. I just want to first thank the organizers of this conference for having invited me, but also given me the opportunity to share the experience of Rwanda in this regard. I will talk about the use of technology in the judiciary before COVID-19 pandemic, then justice rendered during that period, the statistics. I will also share challenges, remedies, and lessons learned, and the way forward. As the French saying goes, l'homme se découvre quand il se mesure à l'obstacle. The human history shows that it's during times of big unrest like wars, pandemics, and other big calamities that many innovations are born and boost the development in many ways, including in the field of technology. In this regard, Rwanda is no exception. In the context of 1994 genocide aftermath, the government of Rwanda has had to devise many strategies in order to cope with the genocide consequences and to lay out new pillars for sustainable development, among which was the use of ICT throughout all public institutions and private institutions. Ever since 2016, the Judicial of Rwanda has been using a system known as ICMS, or Integrated Electronic Case Management, which, among other things that will be explained later in this presentation, allows the electronic case filing, streamlines the case flow throughout all justice sector institutions, and facilitate seamless reporting to regularly enhance performance evaluation for an informed decision making. As you can see on the screen, the things you see there are the features of the ICMS. With the ICMS, you can file your case online. There is also some other features like advanced document management, whereby you can retrieve document you want to consult while maybe writing a judgment, or if anything you want to add to you're working on. Then the ICMS also has it's a role-based access, meaning each one has the field where he can work, which is not seen by other participants in the system. The form generated and the e-signature, it's also among other features. It also has a help desk where courts can interact with litigants. There is a lot of things you can see there. I will not go through everything because of time. The ICMS, next slide. The ICMS, as I mentioned, integrates all justice sector. It goes from criminal investigation to public prosecution, to the judiciary, to correctional service, to civil litigation, judgment execution, and litigant and advocate service module. You can see that the case can be initiated from investigation if it is a criminal case. From investigation, then to public prosecution, then to the judiciary, then to correctional service, the person, the accused is put in jail, or if it is a civil matter, it can go to judgment execution. But also a case can be filed if it is a civil case from a litigant or legal representative side, then it can goes to court and then to execution. It can be also, an issue involving the government, what we call civil litigation, and then the case can go to the judiciary, then to execution as well. The case is processed throughout those, this is a case flow, and there is no need to use paper. Our court, since 2016, we are already paperless courts. The ICMS also have interface with different other institutions which are not part of the justice sector. This includes national ID system to make sure that the information you have of the suspect or any other litigant is the correct one. Then the Rwanda Revenue Authority, whether a case is or concerns a vehicle, you use it to identify vehicle number plates. Whether a case has something to do with land, then the system is interact with the Land Administration Information System to retrieve unique personal identifier for cases, as I said, involving land. The ICMS also interface with the criminal record system. Then we also have online payment and other government systems. Now, it was in that context that actually COVID-19 found us. Rwanda entered the period of total lockdown between 16th March to 31st May 2020. During this period, in Rwanda, like in many countries, socio-economic activities and public services were paralyzed, of which Rwanda judiciary system was no exception. The COVID-19 outbreak forced the limitation of people's movement and hence caused the reduction of the judiciary's day-to-day operations. However, the judiciary remained determined to ensure that the wheels of justice do not grind to a stop, even during the total lockdown. In order to ensure the safety of court officers and court users, the Higher Council of the Judiciary issued a direction halting the in-person interactions of litigants as well as the court officers in courtrooms and court premises. Court staff were destined to work remotely, whereas litigants would access court services online. Case filing, thanks to ICMS, all institutions of the justice sector, namely Rwanda Investigation Bureau, National Public Prosecution Authority, the Judicial of Rwanda, Rwanda Correctional Services, Rwanda Bar Association, and Civil Litigation, could file, register, and follow up their cases. During the total lockdown, in the judiciary, over 20,618 cases were submitted, among which 13,660 cases were registered after passing the test of admissibility scrutiny. The Rwanda Investigation Bureau received 14,227 complaints, while the National Public Prosecution Authority received 10,510 complaints, and they processed 10,501 complaints. This ensures that even during the lockdown, citizens had access to justice and their complaints were addressed. The figures you see there are the one I've already mentioned. Next slide. Apart from ICMS, we also used other systems like physical video conference facilities and Skype for video conference hearing. Video court hearing. Video court hearing began as a pilot project in courts, having in their jurisdiction over congested cell facilities. These were mainly around the capital of Kigali, using physical virtual conference facilities and Skype. It was then rolled out to the rest of the courts and the country, such that 2,064 cases were presided over and disposed of during that period. Rwanda Judiciary has also other 5 online ways through which court staff and the litigants can interact. These include ICMS via its help desk functionality, which is an application, a platform which, among other things, serves as a suggestion box, the toll-free line, the judiciary websites, and the court emails. Judgment could also be executed, and we have also an application of online auctioning. I don't want to dwell much on the figures you can see. That's right. But as you can see, thanks to ICMS, the COVID-19 did not affect very much the court's activities. It's also important to recall that in its inception, the ICMS was thought as a tool to improve efficiency in delivery of justice, to enhance compliance, and hence foster the due process, combat corruption, and other malpractices. It was thought of that it will once turn out to be handy in keeping judicial system operation amid times of crisis. There is ICMS in place. The Rwanda judiciary seamlessly transitioned to remote operations during the lockdown period, ensuring continuity in case processing and service delivery. Through the ICMS, essential functions such as filing, summoning, and other litigation courts interactions during the trial phase, adjudication, and judgment execution, including online auctioning processes, were facilitated. Nonetheless, in the struggle to cope with the COVID-19 pandemic challenges, we also learned some lessons, among which the following. We noticed that the use of ICT emerged as the most effective approach for ensuring uninterrupted service delivery during cases like during crises like COVID-19 pandemic. Number two, ICMS demonstrated strength, but also its limitations, mostly regarding its lack of virtual hearing functionality. That is number three, Skype was not designed for court proceedings, as the court cannot be in control of in control of the public joining the hearing, resulting in I'm about to finish, the possibility to disrupt the hearing. In addition, its security cannot be fully guaranteed. Practically, that's number four, physical video conference facility can hardly be availed to all courtrooms and court users who are not in correctional facilities. It would also be very costly for all corrections premises to be equipped with VCF, video conference facilities, to accommodate all case hearings sometimes happening at the same time. There was a pressing, that's number five, that there was a pressing need to upgrade the ICMS to allow it integrate virtual court hearing functionality, which is now being developed. The video court hearing we are developing will actually be built within the ICMS system. It has with the virtual court hearing, the privileged user is allowed to manage the hearing session within ICMS. Only facility needed in a computer is a computer and the internet. Simultaneous hearings for various benches throughout the whole country can be held without limitation. Hearing links and notifications are shared to all parties and litigants. Judges' ability to identify all hearing attendants by their name and role in the case. The application can create breakout session for parties. Thank you very much.
Thank you. Judge Mujeri, you have the floor.
Thank you, moderator. And I thank the organizers for this conference. Mine is to share the experience of East African Court of Justice during the pandemic. When COVID hit the world, the judges were not in Arusha. Given the nature of the court, judges are not permanent in Arusha, where there are courtrooms, so they were in their home countries. But before I speak about the experience during the pandemic, just want to talk about the status of use of the new technology by the court before the pandemic and during the pandemic, and this understands and the experience and challenges. In 2017, the court tried to acquire a system called case management, recording, CMRA something system. They tried to use that system, which was not, it was on a phase of trial. It was appropriate and expected to facilitate the court recording for audio and video. It was linked to transcribing of court records and live streaming of court proceedings online, so through the website of the court. And then that was in 2017, and it was on the level of trial. And in the meantime, the court also amended the rules of procedures of the court by adding 2 sections regarding the technology and electronic exchange documents, so that litigant and the court can use the technology, that electronic system. And then they also acquired, apart from that CMRS, they acquired what they call JABs. JABs are those cameras that they call smart cameras. And when they have cameras and microphone, when you start work, cameras start recording what you said. So, and they can also be recorded, and you can be seen on the screen. But all those features were installed in courtrooms. And then COVID came, and IT team of the court tried to look for a system which will be used. They tried many platforms, and all computerized systems were tested, and the court zeroed on Microsoft team. That I'm talking during the total lockdown, when everything shut down. So then they started to use Microsoft Teams for. This was no cost for the court, because as you know, Microsoft is acquired with Office 365, and then it's a package. So they started that using that platform, where all judges were in their home countries and the litigant in their home country, and they used that to try to clear those pending cases which were there, and to do some scheduling conferences and the applications. We have some statistics which shows that, for example, in first instance division, during pre-COVID, in one session, in pre-COVID they could handle 10 applications, and during COVID, they handled that 3 applications. Difference also, the numbers were more than when they were present. But this is explained by the fact that when judges are present, so they sit once a quarter, and also, but that time, everyone was stranded in his home places, so they had time to work on those cases. And also this app, this Microsoft app helped. But then when it was during COVID period, but when lockdown was waived and country people started to move and to resume their workplaces, it was not easy to travel that time. And also the number, they have to restrict number. People could not, stay in a closed place more than 5, and we had to keep that physical distance and everything. But in the East African Court of Justice, they came up with a sort of a hybrid court sessions where you had judges physical or present in the court, but litigants online. So on top of that system, we had in CMRS, which could help transcribing, and JAVS, which could help the recording of voice and video. And they also acquired what they call, this was a Logitech conference, team conference something. So with that, the middle of 3 systems, they came up with that hybrid system when you can have litigant online and judges in the court. That's our experience during the COVID. But we continue to use that system of a mixture of platforms and different tools while we are working on a proper court system or court filing system and management of files, like one in Rwanda or the one they use in Uganda or in other countries. So far, the court has not a tailored system of which we can use or which parties can use. We use a combination of system to deliver justice so far. Then maybe if I can talk about challenges or to come after.
Thank you, Judge. Judge Ajay.
Thank you, moderator, and good afternoon. And we thank the President for this invitation to enable us to participate in this unique colloquium, and we are indeed grateful. Yes, let me start with my country. I'm here in dual capacity, Ghana. I was the director for the Judicial Training School. Now let me start from 1992. Ghana was in military regime, but in 1993, we moved to constitutional regime. Then we had a court act, which was very progressive and over-ambitious, 1993, and it provided that we can use any form of technology to conduct cases subject to the approval of the Chief Justice. That was in 1993. So as time goes on, the successive Chief Justices introduces different interventions. At a point in time, we start with the scopist, where evidence will go on and somebody may use shorthand and others to reduce. Then it progressed to direct transmission, direct transcription, where evidence is being adduced and is being typed, and the lawyers will see, the parties will see, and the judge has a monitor on his table. So at any point in time, they correspond and they are all at peace. They know where they are. Now, at a point in time, Ghana decided to have the full complement of the e-justice. That is the 7. E-filing, e-service, e-distribution, e-management, e-hearing, then e-delivery, and e-proceedings. It was over-ambitious. Then there was the need to amend the existing rules. So we amended the existing rules to permit e-service. So when the first one is e-form, whenever you want to file any civil process, you just go to online, then you fill in the addresses, then you forward it, it is done. Then it is left with service. And service, because of the fact that we have part of the country in rural areas where we find it difficult using electronic means to serve, the law was amended to reflect the fact that where a process is served on the person or the lawyer, the person must indicate whether subsequent processes shall be served on electronic. If the person sees, then the person provides email or whatever. Once you provide, it becomes your mode of service. So we use that one. And it was developing. Then on 12 March 2020, there was announcement that there is COVID, and the government of Ghana said that because of COVID, we are not going to have a full shutdown. We're going to have only partial, because the court, we have some systems that will help us to work, but we should reduce the volume of cases that we had. So we were operating 50% volume instead of 100%. We reduced it to 50%. Now the 50%, we were using direct transmission. When it comes to forms, we did not have problems with the forms because we already have them online. Then when it came to the e-proceedings, that is where we encountered some difficulties. How do you generate the proceedings? Cost implications. And it is not for free, you must pay for it. Now, another issue about the e-proceedings is that when it is produced and it is not a court that has direct transcription, then you need people to go through to edit. But in Accra, where we have a big house, courthouse, that is housing 42 high courts. That one, we didn't have any problem. There's one building which houses 42 high courts. So that one, we're not having any problem. But those in the regions, that is where we had problems. Then another policy was that we have criminal cases. Some of them come from prisons, most of them. What do we do? So we decided to put up courthouses in prisons. So we put up 3 courthouses in 3 different areas. So where the judge is even in his home or wherever, the judge could take proceedings, take evidence in connection with bail and others. The problem that we encountered with criminal proceedings was jury trial. Ghana, we use jury trial. So the issue was, how do we use jury trial? And that's why we could not address it during the pandemic. Even as at now, we are unable to address it. But when it comes to the full automation, the E7, Ghana is making a headway. So now, as at now, we do e-forms, we have e-service, we have e-distribution, because in Accra alone, we have 42 high court in one building. We don't want a situation where corruption would permit people to be choosing their own judges. So once you file, then the next thing is that it goes through the case distribution. Then electronically, a judge is selected and suit number is given. You cannot change it. So then we continued. So as at now in Ghana, the major problem that we have with the e-hearing is about electricity and internet. These two have been the major problem. Because at times you'll be working and electricity will go off. You will come with generator and its associated cost. At a point in time, you may run out of diesel, and that's one. So you have to manage your time. That is the major problem that we are having in regard to this one. Then let me come to the African court. The African court did not have a total close down. It was in session when 12 March came and WHO announced the advent of COVID. So what the African court decided to do was that they needed to amend their court rules to permit them to do 2 basic things. The first one was that filing was by physical or posting. Now there was an amendment to the rules to permit filing by ye. That is, you can file it electronically, and subsequently you make sure that you deposit a physical copy at the registry. So now we have that one. Then it came to the issue of hearing. We needed a rule because you cannot operate where the basic law does not permit you to do. Otherwise, it will be declared null and void. So there was the need to amend the rules to reflect how cases will be heard online. So that amendment was also passed through the rules. And we have it in the rules, we have it in the practice direction, we have it in the judicial practice, that in the African court, we can hear cases either virtual, physical, or combination of the two, the hybrid. It permits us to do that. Then the filing too, we have addressed it. So we are working. Now, let me go back to the local court, just 1 minute and wind up here. The local court, the major issue, another major issue that we are encountering is that the law on the land, as in accordance with all the international rules, is that when you are hearing cases, the cases must be heard in public, apart from where the law says you cannot hear. So in that sense, whenever we are preparing course lists, yes, whenever we are preparing course lists, we make sure that those which are open to the public, it comes to the public, and everybody will know. And if you want to take part in the hearing, you look at the online, you look at the time, then you join and you participate. So as at now, this is the position that we have in Ghana court as well as the African court. Thank you.
Thank you, Judge. Jesse?
Thank you, Judge Aegis. I would like to thank the president and the organizers of this conference for putting this on. It might compete with trying to hold a trial in the midst of COVID, all the logistical challenges that you have to overcome. I'm going to talk about the experience of the mechanism and its use of technology in response to the COVID-19 pandemic. As Judge Aegis earlier said, the mechanism, building on the legacy of the ICTR and the ICTY, already had very advanced technology at both branches. And as a mechanism, it was already pretty interconnected. But the pandemic did need to accelerate the development of further technologies to allow criminal proceedings at the court to proceed safely and fairly. And one of the unique features, although my colleagues on the regional and continental courts are aware of, is judges, parties, in our case, defendants and witnesses aren't necessarily in the same location, and it can be on 3 continents at once, actually. So that was a particular challenge for us with travel and quarantine restrictions. So I'll talk a little bit about the technology that the mechanism had and developed. The mechanism operates on 2 branches, one in Arusha and one in The Hague. And during the COVID pandemic, they managed to link those courtrooms electronically. In response to the COVID pandemic, we also developed technology in the Kigali field office, so witness evidence could be taken directly from there as well. The mechanism already used an electronic filing system for all of its filings, so that was already in place. Parties and the judges were used to that. But with the development and the need to use kind of remote working environments, with the 2 branches, the courtrooms at both branches, we were able to connect locations and view them simultaneously. Testimony and submissions were able to be broadcast in multiple languages simultaneously as well. And I might emphasize the mechanism had the capacity to use secure networks for the transmission of electronic video and testimony. We also had electronic transcript feeds, and exhibits could be displayed on computers in front of all the courtroom participants, no matter wherever they were. The video technology was could be controlled remotely by one IT expert in one location. And I'm going to talk about our experience using mostly remote participation in proceedings in the context of a few proceedings that were happening during the pandemic. And I want to stress that we really benefited from the technical expertise of the registry staff, as well as the competence of the judicial support that we got, where we had officers who were well equipped and well trained to deal with taking testimony from people in different locations. So we were in the pretrial phase of a multi-accused contempt trial at the Arusha branch of the mechanism when the pandemic broke out. But with certain adjustments and largely with the agreement of the parties, we were able to conduct a trial between October 2020 and March 2021 before most of that courtroom's participants had the COVID vaccine, or it was even available to them. The single judge in that case, Judge Jonsen, who's in here and can speak to this as well, he authorized counsel to appear remotely from The Hague while he and the defendants and witnesses the defendants and witnesses were in Arusha. In that situation, we were able to hold hearings where there are even a witness in a remote country, and counsel were either able to follow from Arusha or The Hague, and the judge and the defendants from the Arusha courtroom. We also have the case of Felician Kabuga. He was captured in the midst of the COVID pandemic. And so getting the bench together and the defendant in a single place presented a challenge due to logistical and safety challenges. But later, as his health waned, there was also a need for him to be able to choose to participate in his proceedings from the UNDU. So we were able to link the detention unit with the courtroom in The Hague. He also was unable to travel to Arusha to be tried in Arusha, so he and the bench remained in The Hague, but we still had proceedings here in Tanzania. We heard, I think the trial chamber authorized more than 30 witnesses to testify via video conference link, and the witnesses testified either from here, 17 witnesses testified from Arusha, or in the Kigali field office that was also securely connected. We also had the Mladic appeal, which was ongoing as the pandemic arose, and the appeals chamber had to hear the appeal arguments in that case in 2020. This proved very difficult again, and with the expertise of our tech staff, the appeals chamber was able to conduct the hearings remotely with judges appearing from their home jurisdictions. And at the conclusion of that case, they followed the same practice and were able to deliver the judgment with many of the judges participating remotely all over the world. So those are kind of the examples of the successes of the mechanism during the pandemic, and then I'll wait to discuss the implication on the rights of defendants after we hear from our colleagues. Thank you.
Jesse, as I said in the beginning, when introducing the subject, one of the main concerns that my team and I had at the time was to first realize that this was not a normal, but an abnormal situation that we were dealing with. And that the working methods that we were putting in place were not exactly the best that one would aspire to in criminal court. And we had a main concern to make sure that as we went along, we will not end up with a situation where the accused, for example, would come forward and say, you violated my due process rights. Let me give a simple example, and you will understand me immediately because you lived through this like me. Let's take the Mladic appeal. There were days when, for example, counsel couldn't travel to The Hague, and a postponement was asked for. There were days when Mladic wouldn't come or was not allowed to attend the courtroom. And a question of communication between counsel and client at times became important. We needed to make sure that there were no shortcomings and that eventually there would be no grounds for any claims of miscarriage of justice. So what's your experience? Because these were not normal proceedings. I remember in Mladic, I remember watching it from home because I myself was not even allowed to attend the tribunal. I was barred, like many others. And when I attended, we had enclosures, plastic, whatever it was. So it was not an easy situation, but I had to supervise and make sure that everything was according to the book. I suppose this was also happening in your respective country or your institutions. Perhaps you could briefly deal with this, Judge.
Thank you, moderator. Of course, this happened as well in our country. As I said, even if we had the ICMS that could allow people to file cases, follow up what is happening in their cases, we had the problem of e-court hearing. Then we had recourse on Skype, video conference facilities. But as I said, video conference facilities were few in some few premises. Skype could be accessed by a lot of people. But still, as I said, there are challenges with Skype in terms of security because this is not a court-made application. So we managed to use it, knowing that there is a risk, but fortunately, so far, we haven't yet got any impact, negative impact of having used it. But fortunately, as I said, we are now working on a new e-court hearing, which will be built in the system in the way that anybody from anywhere can use his gadget, meaning the computer. He can be, as if he is connected to internet, he can follow up or submit applications or even be heard in court using those facilities. And this is to be done next year. We'll be using it fully. Thank you.
Thank you, moderator. Yes, although courts try to find solution, I mean the East African Court of Justice, that to continue its operations, there were also many challenges. As Judge from Ghana said, there were that problem of power when there is no power from some countries. So judges would be online conducting hearing, and then one litigant go off because of power or internet cut. There had also some cases where this is the case of one litigant from Uganda, refused to appear online, wanted to be present, physically present in Arusha. So there were, for him, he said this would be his right to be present and to argue his case presently, not online. And we had also other challenges. There were also those challenges where we had litigant in one place and their lawyers in another place, so that they could not have litigant to interact with their advisors on what to say or what not to say. So that was also another challenge. There were also many challenges. Even judges, when before they resume works in Arusha, judges also were online, and being online, the consultation, every judge in his home country was not so easy. And there's also this threat of cyber security attacks, and also in East Africa, I think we had those who they are called hackers in the system, this CMRS system. Now it's obsolete. We no longer use it because it was attacked. Those are some. There are more challenges, but although we tried to continue our works, but there were also, we encountered a lot of challenges. Thank you.
Thank you, Judge. For the African court, we don't encounter much difficulty because most of the cases, the deliberations are held in camera. It is not exposed to the public, unless where we are having a public hearing. And public hearing is not a thing that we have it quite often, except where we know that looking at the nature of the case, we require that there must be a public hearing. Otherwise, our deliberations are made in the session room to the exclusion of the judges and legal officers. And even if you are a judge and the respondent country is where you come from, you are not supposed to take part in the proceedings, as well as any of the officers in the court. So, for example, if there is a case against Ghana in the court, I'm not supposed to be there. If you have Ghanaian staff, they are not supposed to be there. So that is how it is done. But when it comes to Ghana, then, because that is where we do actual hearing, that is where I need to talk much about it. In the case of Ghana, we were using video conferencing to hearing cases. But during COVID and after COVID, we saw that the evidence that you could obtain will not be the truth of the matter. Because video conferencing, it will not inform you whether somebody is behind the witness and the person is informing the witness what the person should say. So we decided to acquire, we call it evidence technology mechanic. So that if you are within a certain radius and somebody is whispering, the censure will indicate that somebody is there, so the evidence is not free. Then another thing that we want also to assure is that we want to make sure that when witnesses are testifying, they testify under free, not under any pressure, under duress, and the evidence that they give is the true evidence that they will proffer, particularly when it comes to the turn of accused persons. Then another issue that we are still grappling to address is where the accused person is illiterate in English. The lawyer understands English because we conduct cases in English, but the lawyer may not understand the language that the accused person speaks. That is where we have another problem. So here, what we are doing is that we are introducing interpretation. But the interpretation, so here, because if you are not in the same courtroom, but the accused person is in prison, the lawyer is in his office, and the judges in Ghana, the policy is that you cannot do it in your home. We want all the judges to be present. The reason is that when it comes to hearing, we are not only assessing the parties before us, they must also assess us, our demeanor. So we must also appear in TV or camera for them to see us, that the judge, he was sitting as a judge, his demeanor was perfect as a judge. So these are the things that we are encountering. but I believe it may take some time, not within maybe 3, 4, 5 years. We may go beyond that one until we are able to address fluctuations in internet, electricity problem. We will still have problems. So even though we aspire that at a point in time, we shall have pure e-hearing, still we have difficulties. Thank you, Judge.
Yeah, thank you. Yeah, I think the mechanism did experience considerable success in leveraging technology to conduct remote proceedings, and a lot of that was done with the agreement of the parties, and including the defense counsel. But sometimes there was an agreement. But in criminal proceedings, of course, technology can expedite them, and it can ensure a defendant's right to be tried without undue delay. We had force majeure. We needed to get trials and appeals done, and technology really helped. But using technology, it can implicate a defendant's right to be tried in his or her presence and their right to examine witnesses against them. And so that needs to be carefully considered when you're using technology. And I think this is where the mechanism has benefited from the resources and the experience that might not be available in more domestic jurisdictions. I think the connections, the secure connections we were able to establish, the power, the experienced IT staff, there weren't necessarily disruptions to evidence that are caused by a remote proceeding because of logistics, because of power running out. So we really benefited from that. But again, a defendant's right to be tried in his or her presence is really at its apex when it involves the presentation of evidence. So I think one of the experiences and what you can learn from in this context is that using remote proceedings can be, in a criminal context, can be uncontroversial and highly efficient when it doesn't involve the presentation of evidence. So status conferences, maybe pretrial conferences or conference trial management hearings can be done in that way, and it's uncontroversial. In the Mladic case, and Judge Nyambe presided over that, she's also here, and there were considerable difficulties with the defendant, who is an appellant in that case, about complaining about whether or not he would be able to come to his appeal hearing or even the delivery of his judgment. And the appeals chamber carefully considered that question. And for the appeal hearing, they noted that there was no evidence that was going to be presented at that hearing. And he has very skilled counsel who's normally going to take the lead in representing him. So having an appeal hearing in that context didn't infringe on his right to be tried in his presence. And I note that the appeals chamber also emphasized that there were communication facilities between the defendant and his attorney should he not come to court. I want to talk a little bit about the Kabuga case, and we have two judges from that trial chamber who are here as well, Judge Bonamy and Judge de Guzman. And I think that case really puts this question into focus about using remote proceedings and defendants' fair trial rights. And in that case, the trial chamber authorized the taking of video conference link testimony of, I think, more than 30 prosecution witnesses. And there's a rule in our rules of procedure of evidence that allow video conference link evidence to be heard if it's in the interest of justice. And I'll talk about, I have to look at my notes so I don't misstate this, but there was an omnibus motion by the prosecution in the beginning to allow video conferencing testimony for a large number of witnesses. And the chamber ultimately authorized it, focusing on the importance of the evidence of these witnesses who are going to be unable to come to The Hague, where the defendant and where the trial chamber was sitting. the need to ensure the timely and regular flow of witness evidence, and some of the logistical challenges that were posed because the defendant was sick and intermittently ill. It would cause, there could be situations where witnesses could be coming from a different continent and stranded in The Hague for who knows how long, while the defendant might be recovering from an intermittent illness. And then there are also logistical difficulties in securing the transfer of detained witnesses from Rwanda to the Netherlands. The trial chamber granted this motion, authorized this testimony, and it emphasized that it was going to closely monitor how this was implemented in the trial, and it could revisit the questions of fairness should it appear that the defendant's fair trial rights were being infringed on. The defense did oppose this motion. They didn't appeal it, and I think this is both really a credit to our IT staff. There were certain instances where the parties were allowed, where a witness was testifying remotely, the parties could be at the location where the witness was. And there were certain instances where in that trial, witnesses were testifying from the Kigali field office, and the defense actually opted to examine the witness from The Hague, a prosecution witness. So I think that from this experience, using remote technology, particularly when it involves in the presentation of evidence, should be used judiciously. It's not a panacea, but there are clear advantages to it. It can be cost effective, avoid the need for counsel and witnesses to travel. It can mitigate the burdens on witnesses, and particularly victim witnesses who might not want to be in the courtroom with the defendant. And, you know, with international criminal trials, we have victims of sexual assault. And so the possibility that testifying can result in re-traumatization is a real concern. And I think with good technology, some of the normative considerations about being tried in your presence, having a defendant tried in his or her presence, and examining witnesses, the risk that the examination isn't thorough enough because they're not in the same location starts to be a less compelling argument.
Jesse, for those who don't know, the problem was really convoluted. For example, in The Hague, basically in the Netherlands, there were new regulations introduced which banned travel to the Netherlands from a huge list of countries during the COVID, irrespective of whether what was happening in that country. And then there were other countries, including mine, where you had to present a COVID-free certificate, PCR or whatever it was called at the time, as recently taken as 48 hours before. And this impacted on many witnesses that otherwise would have had to travel to The Hague. And even lawyers. I remember lawyers being told you cannot travel to The Hague. Not only that, even judges. One time there were a couple of judges who were unable to travel to The Hague because of this. And it's thanks to the system that we already had in place and improved upon that things became possible, as Jesse has mentioned. And none of you have mentioned the problem of convicted persons. And the reason I understand, because normally courts do not have anything to do with convicted persons once they are imprisoned, unless there are special cases of allegations against their human rights. In our case, it was different. We had all these prisoners a little bit everywhere. We were not actually responsible for them directly because they were being held under the supervision and responsibility of the prison institution in which they were housed. But we took it upon ourselves to ensure that they were being really taken care of and receiving all the necessary care, preventive care, and also medical if needed, in case they were infected. And it was no easy task. And we came up with a system whereby I issued an order to all the countries that were keeping prisoners on our behalf to report periodically to the mechanism upon the condition of the inmates, and in particular as regards when any of them had been infected, and if positively, what was being done, what cure was being provided, and so on and so forth. It was quite a heavy responsibility that we put on all these countries. So much so that after about a year or so, I felt I needed to lessen a little bit the burden. And we still maintained it for, I think it was still on when I left. But we maintained it for a while, making it less frequent. But I must say that we have had cases, or as you can imagine. But I must say that the cooperation I found by almost all the enforcement states was admirable. And I wish from here to say a big thank you, because it was not an easy task for them. We started late, so there is some minutes left, 10, 15 minutes left for the members of the audience to put questions or make remarks. Yes. Judge Waterby?
Thank you, Judge Agius. I want to pick up briefly on something said by Judge Ajay. My domestic jurisdiction is the United Kingdom, and we have jury trials for all serious cases. And it was realized early on that there had to be some imaginative thinking if these cases were going to continue. So concurrently at that time, cinema chains were not doing very well. And the Scottish Court Service managed to negotiate a deal with a cinema chain to take over its cinemas and to locate the juries in the cinema seats, spread with appropriate social distancing. And the court sat with the accused and counsel and the judge, and it worked. It came out of the blue, I suppose, blue sky thinking, but it was a way of getting over the problem that these cases just could not have taken place otherwise. As it is, we couldn't deal with all of them, and there's still built up a backlog. But it was quite a successful initiative, and I think it underlines the need, and it'll happen for some other reason as time goes by, the need for us all to be imaginative in our thinking about ways to address problems. Thank you.
Thank you. Yes, Judge Ajay?
Thank you, sir. In 2020, since the advent of COVID and was announced, we exploited several countries, including UK, because I was the head of the judicial training. I was the chairman for the committee. Then we examined your draft law. And your draft law, which was made in 2019, provided that you will do all of them, but it will exclude jury trial. So 2020, when you passed the Coronavirus Act of 2020 to embrace them on board, you still excluded the jury trial. So we borrowed from you, and still it did not make any headway. And another thing that we must understand is that when we talk about Ghana, we are talking about a country where we have 300 magistrate courts, different places scattered. We have 140 high courts scattered. We have 5 courts of appeal scattered. Then we have 1 Supreme Court. So here we are talking about different courts, unlike where we talk about mechanism, and you can just contain electricity and generator. This is a purely different thing altogether. So your issue on jury trial, we examine yours, and it is part. Now we are taking into account jury trial from 7 countries to enable us to decide which one will best fit our condition. Thank you for the question and the suggestion. Thank you very much.
Any more questions or remarks from the floor? Judge Johnson?
Thank you. Just a small addendum to Jess's presentation. You said about my case that counsel were allowed to participate remotely. It was on the condition that the co-counsel was present with the accused in the courtroom and that they had communication facilities. And also the saying goes that the operation was successful, but the patient died, which also applied to our case because one of the accused actually caught COVID during the proceedings and died during the proceedings. That's all. Thank you.
Thank you. Any further? Yes. Judge Ngo?
Thank you. I just wanted to say that I was in the Mladic appeal, and I felt that it was frustrating doing a deliberation of 5 judges doing it remotely. I still felt that we should have at least had 1 day or so when we were meeting in person as judges deliberating, but that was not possible. And we deliberated online on one occasion, but I felt that we should have had an in-person deliberation. Thank you.
How very true, Judge. I lived through that too, knowing what was happening. And I'm full of admiration for what you did and what you achieved, actually, because it was not easy. Sometimes communications were not easy either. There were problems. Thank you. Go ahead.
Perhaps I should start up. Mine is really a question. I never had the opportunity to do a trial by remote control devices. But so I would like to ask those who have, how do you determine the demeanor of the witness? When you can't actually see or touch him or talk to him like that, what weight do you give to the demeanor of the witness in a trial?
Who would like to address that? Judge Gray? Yeah.
You know, in criminal cases, when it is virtual, we prefer video and not audio. Video, you see the person, you take into account the demeanor of the person. When the question is being answered, the video is there. You see the person, how the person answers. If the person is evading, you have the opportunity to assess all of them. So there is just a marginal difference between physical hearing and online. It's almost the same now, unless you don't have a very good camera, because you see everything, like as if the person is standing before you and you are taking evidence. So at the end of the day, we take into account demeanor and credibility of accused persons. Thank you.
Yes, go ahead. The gentleman over there.
Thank you. Rupert Elderkin from the Mechanism Office of the Prosecutor. And just to add perhaps a behind the scenes observation from Kabuga, which was of great practical assistance for our delivery of the prosecution's evidence, was once the Kabuga trial was located in The Hague, we still had a majority of witnesses located on the African continent. The big fear that I picked up from my senior trial attorneys when I was at the ICTY, when we were in the prosecution phase of evidence presentation, was having a gap in our witness schedule, which was hard enough to manage between the Balkans and The Hague. But if we had had to produce all of our witnesses in Kabuga in person in The Hague, I could well imagine huge numbers of days on which the chamber would have convened, and we would have had to provide some explanation as to why there was no one sitting in the witness box. The use of the video system allowed us to have witnesses. I don't think we had any gaps in our schedule, and that was in large part due to the proximity of the witnesses to the location from which they were going to give evidence.
Thank you. I will take another one, maximum two. Yes, Judge Bossa.
Thank you, Judge Moderator. I just wanted to share our experience in the International Criminal Court during lockdown, and particularly in the appeals chamber. We did deliberate on two big appeals, the Ntaganda judgment and Agbo during COVID, remotely. And we were able to deliver judgment subsequently. So it's possible. The challenge we had was with translation and confidentiality of the deliberations, which the IT team took care of, we believe. But we continued working, and I think even some trial chambers continued working, except that some witnesses and some accused also succumbed to COVID, although I don't think there were any deaths. But we continued with business as usual. Thank you.
Is that it? It looks like it. Thank you very much. I thank the panelists. Your interventions were excellent. And I thank the audience for having participated. Thank you very much.